This is a new trend that we're seeing where people are getting notice of intent to appear the moment their cases get denied. And this is extremely important because it is going to lead to the next wave of problems that people are going to face. In this case, it was a mother who was visiting her daughter on a tourist visa. She filed the extension, she had a surgery, and the extension took so long that she just decided to leave. But the case was denied, and then she got the notice of intent to appear. Luckily, she left before she received the notice of intent to appear. And you might think, what? Why would she get a notice of intent to appear at an immigration court for a tourist visa saying that she has to leave when she's already left? This seems really dumb and a waste of taxpayer money. That is obviously what everyone thinks. And we obviously reached out and said, can you just close this trial, please? Right? Like the person already left. It turns out the trial attorney couldn't be reached because she was out of the office. The court couldn't be reached because they were in backlog. And so it's up to the trial attorney. So nobody could respond. We have to show up for trial. During the trial, at least we were able to be placed first and say and make this request. Please just close out this case. The client already left. The trial attorney wasn't willing to. The trial attorney said, I don't know if she left. And the judge looked at us and we said, you literally represent customs. You have it in their data bank. There was a I-94 record of her leaving. You can check. We already provided a proof that she left, the plane tickets and everything. And the trial attorney said, well, I can't go based off of the proof that you provided. Well, you have access to the system. Why don't you just check it? You had all this time to check it. You have time to check it before you issued the notice of intent to appear. Why did you issue the notice of intent to appear before checking? Why didn't you check? The judge was actually quite fond of this argument. I said, do you have access to the system? The trial attorney reluctantly said, yes. Then the judge said, well, can you check then before we decided we should terminate this proceeding, right? Because the alternative is for the trial attorney to say, no, let's kick it to the next hearing and let's wait, 3 months, 6 months, and then come back to this trial. So 2 trials for a case to determine whether or not this old grandmother have already left the US or not. The judge asked, can you please check the system? They're like, all right, fine. But she couldn't log into the system. It was like glitchy. And so we were bumped down to the end of the line and we have to wait for everybody else's trial to go. And then finally in the end, when it got back to this case, the trial attorney said, all right, I see that she has left. And then so the judge says, okay, so do you agree to terminate this case then? Right? Because the attorneys requested to terminate this case because the person already left. The trial attorney said, I will defer to the court. That is the situation at immigration court today, where trial attorneys cannot make common sense decisions because they're under so much pressure to oppose everything that is pro-immigration. And the trial attorney, the judge said, fine, we'll close out the case. We closed it. Now, had the mother left the US after she got the notice of intent to appear, this will be another argument entirely. The trial attorney could have said she's fleeing the country, so we're going to put it on her record that she is removed in absentia. And think about that. All right, let's assume that does happen, right? Not everybody can hire an attorney to do this sort of bogus trial where you go up and you purely state, I've already left. You're telling me to leave, I already left. Like, what's the point? But had they not done that, even this case would have been in removal in absentia. And if she does have an removal in absentia order, good luck trying to get any other visa to come back to the US, right? Again, this is a grandmother who came to the US to visit her daughter, had surgery, had to stay, pay out of pocket and everything, and then filed an extension, paid for the extension, but it was taking so long because the government is so slow, and then she flew home. Something so simple, but now suddenly she is in the same bucket as everybody else who got removed for being illegal in the United States, and she loses out on all future privileges of getting a visa. Think about that. Some things are not that severe, but a notice of intent to appear is something that needs to be dealt with. And unfortunately, the situation in the climate that we're in, There's so few immigration judges, the cases are so backlogged, and trial attorneys are required and ordered to oppose everything. Hopefully, everybody who gets a notice of intent to appear responds on time and is able to reopen if they got in absentia removed and be able to close out that case. But this is going to have a lasting effect on American civic life for the next 20, 30, 40 years, because everybody who gets this, a lot of people who got it, they don't even know they've been removed until they go back for another visa appointment years later. But we're happy we close out the case. The mother's happy, the daughter's happy, we're happy, and in the future, we'll see what happens to them. If they want to get another visa, at least they don't have that stain on their record.